We have two new filings in the Garcia v. Noem case. The first one is document 64. It's the declaration of Evan Katz. This is the case involving wrongly taking this person over to El Salvador and being ordered by the district court and the Supreme Court to bring him back. Yesterday, we did have a declaration from another person, Mr. Kozak, and so today we have Evan Katz. I, Evan C. Katz, pursuant to 28 U.S. Code Section 1746, declare under penalty of perjury as follows. 1. I am the Assistant Director for the Removal Division within the Department of Homeland Security, U.S. Immigration and Customs Enforcement, ICE. Enforcement and Removal Operations, ERO. In this capacity, I'm responsible for leading the division, which is composed of ICE air operations, international operations, and removal management. I coordinate with the 25 ERO field offices to support case management and facilitate the removal of aliens from the United States. I've held this position since December of 2023. Before this assignment, I served as the Acting Assistant Director for the Removal Division from January 2023 to November of 2023, and Deputy Assistant Director for the Removal Division from January 2015 to December of 2022. I've been in service with ICE since 2003, and prior to that, the Legacy Immigration and Naturalization Service since November of 1997. Page 2, paragraph 3. I provide this declaration based on my personal knowledge, reasonable inquiry, and information obtained from various records, systems, databases, other Department of Homeland Security employees, and information portals maintained and relied upon by DHS in the regular course of business. So, hearsay. Number 4, I'm aware that the instant lawsuit's been filed regarding the removal of Mr. Abrego-Garcia to El Salvador. Number 5, I'm aware that after this, court's preliminary injunction issued that the government sought a stay pending appeal from the Fourth Circuit on the same day, and ultimately the Supreme Court. On March 7th, Chief Justice Roberts issued an administrative stay of that preliminary injunction order. On March 10th, the Supreme Court held that the deadline in the challenged order is no longer effective, and that aspects of this court's injunction needed to be clarified before they could become effective. Paragraph 6. During proceedings in 2019, the immigration judge upheld DHS's decision not to grant bond, finding that DHS's determination that he was a member of this really bad group was, quote, trustworthy and, quote, supported by other evidence, and noted that Abrego-Garcia, quote, failed to present evidence to rebut that assertion. The Board of Immigration Appeals upheld the finding when Abrego-Garcia appealed. This was in 2019. Paragraph 7. On March 15th of 2025, Abrego-Garcia, native and citizen of El Salvador, was removed to El Salvador pursuant to Title 8 of the United States Code. Although Abrego-Garcia has an order of removal issued by an immigration judge, I understand that he should not have been removed to El Salvador because the immigration judge had also granted Abrego-Garcia withholding of removal to El Salvador. However, I also understand that Abrego-Garcia is no longer eligible for withholding of removal because of his membership in this group of bad people, which is now a designated foreign T-or-rest organization. Number 8, I've reviewed the declaration of Mr. Michael Kozak, which was filed in this case yesterday, April 12th. It's my understanding that defendants have no updates for the court beyond what was provided yesterday. I declare under penalty of perjury that the foregoing is true and correct. Executed this day, 13th day, April 2025 by Evan Katz. All right, couple things, everybody. First of all, if you're doing a declaration giving a status update, it's not a chance to actually argue your case, right? Like, we have hearings and we have court proceedings in order to argue your case. Facts and evidence get presented according to the rules of evidence, not just hearsay and what you think somebody said to someone else and then to you. We have rules of evidentiary procedure. Now, you're not arguing your case in a statement. And so this person who is trying to say, well, he's over there, okay, right after he already said, well, we know he's not supposed to be there. But based off of, I guess his word, or his hearsay word, that this person was part of this group of bad people. And so somehow it's okay that he is over there, even though this isn't a hearing. We're not arguing this out. We have no due process guardrails in place. We just have this person's word based off of his understanding of the situation. So as far as this being a status report on actually moving Mr. Abrego-Garcia from El Salvador to the United States, this does nothing. He just says nothing's changed. By the way, here's some information that I have that is not relevant to the order of the district judge that was supported by the United States Supreme Court. That's not great. It's not great. We do have another filing that was put into place today. Also, defendant's response, plaintiff's motion for additional relief, and I will be reading that tonight, which is April 13th, 7 o'clock Central, over on my Tube of You channel. So if you want to come and hang out, and that's about a 7-page motion, and we'll talk more about it. We'll do a Q&A and kind of clarify some things. You can catch me at 7 o'clock tonight on a live over there. But as far as information goes, I do not think that this declaration is actually in compliance with the order. And I'm not really sure what they're trying to do here other than just have something filed on time, I guess. It's quite disturbing, and it's not getting any better for the government.